Judgment in the appeal, She and the Scottish Ministers and the Mental Health Tribunal for Scotland.
Lord Reid will summarise the judgment of the court.
Mental health law in Scotland was reformed by the Scottish Parliament in 2003. One of the reforms was the introduction of a right for patients detained in the state hospital to apply to a mental health tribunal for an order declaring that they are being detained in conditions of excessive security. If the application is successful, the responsible health board is then under a duty to identify another hospital in which the patient can be detained in appropriate conditions and in which accommodation is available. The purpose of a reform was to address the problem of patients being trapped in the state hospital when they are no longer required to be detained under such secure conditions because of a lack of suitable provision elsewhere. This appeal has been brought by a patient who is detained in the state hospital. The Mental Health Tribunal held that he did not require to be detained under conditions of security that could be only provided there, but nevertheless refused his application. He appealed against that decision to the Court of Session, but his appeal was refused. He now appeals to this court. The court has decided unanimously that the appeal should be dismissed, for reasons set out in a judgment delivered by myself with which the other justices agree. Lady Hale adds further observations in a concurring judgment. The appeal raises a number of questions about how the legislation should be interpreted and applied. In particular, where the Mental Health Tribunal finds that a patient does not require to be detained under conditions of security that can be provided only in the state hospital, it has a discretion whether to grant the application. It is required by the legislation to exercise that discretion, having regard to a number of specified factors and to such other matters as are relevant in the circumstances, and in the manner that appears to it to involve the minimum restriction on the patient's freedom that is necessary in the circumstances. The main issues that arise in the appeal concern the matters that may be relevant to the exercise of discretion, and whether the discretion to refuse to make an order should be exercised only in exceptional circumstances. The court holds that the risk posed by the patient to the safety of others is a relevant consideration, as also may be the quality of treatment available at other hospitals compared with the treatment available at the state hospital. The wishes or feelings of the patient should also be taken into account, and the patient should not be treated in a discriminatory manner. Where the tribunal finds that the patient does not require the level of security available only in the state hospital, it should make an order unless there is some good reason not to do so. But that does not mean that it is only in exceptional circumstances that an order should be refused. On the facts of the present case, although the tribunal found that the appellant did not require the conditions of security available only in the state hospital, it also found a number of reasons why he should not be transferred elsewhere. First, he would pose a risk to the safety of women until he had completed suitable treatment. As the hospital to which he might have been transferred had female patients, unlike the state hospital, that meant that he would have to be subject to greatly increased restrictions on his movements if he were transferred there until the treatment had been completed. The treatment was likely to take 12 to 18 months. The restrictions on his movements over that period would place his mental health at risk. In addition, the tribunal found that the state hospital was best placed to offer the most suitable treatment, and that the appellant was more likely to undertake the treatment there. In these circumstances, the court holds that the tribunal was entitled to conclude that the application should be refused.